a paper which in some sense I call the sort of anti-hand paper, which is designed to sort of explicate a second tradition in dealing with the question of negligence and fault in the common and, I dare say, civil law system. And it starts off with a series of terminological observations. It then has a middle section in which it tries to give a brief theoretical explanation as to why heterogeneity in the so-called fault standard should be the norm in the contracts cases once they're distinguished from the tort cases. And then there's a sort of an effort to look at a variety of cases which sort of exposes the confusions that can happen if you don't keep the categories straight and distinct. And the first point I think that one wants to make is that the word fault is one of these chameleon words that one has to be extremely careful of with respect to their use. Lawyers, by inveterate nature, will tend to treat the word fault as though it's a synonym with negligence, and negligence is also a synonym with respect to reasonable care under the circumstances, and kind of find a universality that covers all times and places where all the ability to deal with variation comes in figuring out what is reasonable under the circumstances. One might wish to describe this as a sort of a high standard situation relative to a more rules-based approach. If you actually go back and look at the way in the origins and the roots of these particular words, it turns out that they're not necessarily parallel. And indeed, in ordinary English, the word fault is sometimes associated with blameworthiness, which is itself not a standard of liability, but simply a judgment that there's some standard of liability under which somebody ought to be held accountable, as opposed to negligence, which is the particular standard of liability. And within the framework of this sort of general fault standard, it turns out that you see a range of standards that emerge in many cases on the contract side of the line, which vary from situations in which you're strictly liable except for vis maior, a concept which came into play yesterday, down to the other end where it turns out that you're only responsible for your willful neglect, a term which was given more cognitive content by the ancient scholars than is given by the modern economists who always see it as a smokescreen or for something else. And in between you do have standards which are close to ordinary negligence. Interestingly enough, their formulation tends to be different from the hand formula BPL. They tend to talk in terms of ordinary care, and the implication is not that we want to get inefficient results, but that the method by which we get the results that seem to make sense is to sort of observe the basis of care that we start to see, and then to infer from that what other people ought to do. So it's more reflective and observational and less deductive from first principle, meaning in effect that sociologists and students of human behavior have a larger place to play in this particular world than economists who could come up with fancy kinds of models. So you might want to call this the Economist Unemployment Act of 2007. So that's the first part of what it is on the question. And then the issue is, how do we figure out what these standards are and what we're working with them? And as we've said in many papers yesterday, there is clearly a great deal of importance that has to be attached to the contract tort line, because people sense, however intuitively, that there is going to be two things going on simultaneously. One, a difference between some tort cases and some contract cases, and at the same time there's a fairly substantial overlap under conventional wisdom, both in the civil and in the common law tradition, between tort and contract, mainly with respect to those cases which deal with the loss or destruction of property which happens to be shared under some kind of a contractual arrangement, of which bailment is the most common, but by no means the only one. And the first thing I think one wants to do in order to straighten this universe out is to make sure that overlaps do not exist. The problem with overlap, quite systemically, is that there are two roads. Either they're perfectly identical, at which point you don't need them, or that they're different, at which point you can't figure out which one you're supposed to take. So either way, it's either redundancy or confusion. We might as well get rid of it. Well, then you have to figure out a way in which to do the classification. And I go back to, again, which I think is a reasonably strong civil law and classical common law tradition, which is that stranger cases are governed by one set of rules, and those cases which arise out of consensual reactions are done on another. And the way in which you link the two of them together under some circumstances is assumption of risk may be a consensual defense against what would otherwise be a stranger case, and bring them back into the world of contract. And with respect to the stranger cases, you do have the ultimate question of care. And the battle is always between high objective negligence, often aided by res ipsa loquitur on the one hand, a point that Professor Brunsman talked about yesterday, as against strict liability, where the key and operative point is to understand, as Barry Goldwater used to say, there isn't, in the grand scheme of things, a dime's worth of difference between the two positions. even though there will be many subtleties with respect to the way in which litigated cases will be argued. And the basic intuition in all of these cases is that the externality risk is so great by virtue of the fact that somebody could internalize the gains from conduct and externalize or dump the cost on somebody else, that you have to look at it with a very skeptical eye, given the dangers of self-interest. Now, when you start getting over to the consensual cases, how does this relate to the stranger cases? And Vaughan and Menlo, which is generally treated as the defense of the objective standard of negligence in certain kinds of indirect fire cases, is extremely instructive on this matter, because in an effort to define what the appropriate standards of care would be, all the lawyers and the judges reverted to the bailment cases, which are the quintessential consensual kind of an arrangement. And for those of you who don't know what a bailment is, which includes everybody who basically has never studied bailment, it is simply an arrangement whereby a chattel is given to one person with the obligation to restore it under certain terms. And one of the key questions when you're dealing with bailments, many of which are informal, lending somebody a pen, for example, is what are the default terms and how do they reflect the way in which the world is organized? And in Vaughan v. Menlo, what the defendant wanted to say is so that this is not a bailment case, and then he drew a complete non sequitur and said, so therefore we could use a very low standard of care. When in fact, if you start to look at the bailment cases, it points in exactly the opposite direction. Because the way in which they tended to divide the world was in terms of a division of benefit and cost with respect to the arrangement. And to the extent that you're dealing with those cases where all the benefit went to the person who's making the bailment, to the person who's receiving the bailment, he's going to be under an enormously strict standard. And to the extent, therefore, in the fire cases, that the guy who sets the hayrick up is the one who's internalizing all the benefit, what you'd expect to see is not a good faith standard, but a very strong, strict liability standard. And the question then comes, if you look at the bailment cases, there is here a perfect synonymity between the Roman and the English tradition, because the English tradition in Coggs v. Bernard essentially imported the Roman classifications wholesale. And there's no question that they were trying to figure out what counted as some sense of an efficient relationship. But this is basically an exercise more in rule utilitarianism rather than in the hand formula act utilitarian tradition. And what the typical way of doing things was to run classifications, admit that there would be borderline cases, and then when you're dealing with the situation, get the core cases correct, and simply leave litigation to pick up the pieces. And the greater the degree of regularity, the more powerful the classifications will be. One most distinctive feature in this area is, of course, what is called gratuitous bailments, because they don't fit very neatly into the common law of contracts in virtue of the fact that there is no consideration with respect to the promise. And so therefore what you have to do is to figure out how it is that you can extend a contract-like notion to a situation which is not contractual under English law. And this is where the sort of the manifest deficiency or comparative advantage on this point of the Roman law, I think, becomes really quite evident, because what they understood is that the key element about gift transactions is you could never compel anybody to go through with them. And so the way in which you adjust that to bailment, which is a contract essentially for gratuitous services, is to say that you cannot compel somebody to take it if it gives you notice in time for you to find somebody else, just the way you can in fact repudiate a gift promise to make a $1,000 cash transaction. So you have that. But once the thing is now transferred over, the issue is no longer whether you can enforce the contract, it's now the risk of loss question. And here I think it's important to understand what the central allocative factor is in deciding that you're going to use a low standard of care, by which we mean good faith, by which we mean, for the most part, the adoption of what modern economists actually call a non-discrimination principle, which has a lot of sort of social utility associated with. You will bring to the care of that thing which you receive under a bailment the same level of attention which you would bring to your own things, as opposed to the situation where you're talking about merchants, where the general rule is there's an ordinary best practices in this particular field, and that you as a merchant holding yourself out to stuff now agree to do it to the upside standard. And the question you have to ask is, why is it that this dichotomy seems to work pretty well and tend to induce a high level of care, even in the area where the non-discrimination standard in good faith is there? And I think that what you're talking about here is really a kind of an information story about how bailments are organized. On the one hand, if you're starting to deal with individuals who are in casual relationships, the key element for keeping the system efficient is that the bailor who owns the goods, which he wishes to have somebody else to store for him, will have a very strong power of selection based upon real information about who it is that's doing what. If you tell him that there's a non-discrimination standard on the other side, he's going to have a natural inclination in his searches to try to find those friends which are most responsible, so that if they bring a lot of care to the storage of their own goods, they're going to bring a lot of care to the storage of his. So if you've got a piece of artwork that you want to take out of your apartment during the summer, what happens is you don't want to store it with somebody who believes that every piece of furniture in his house is trash and the only college posters he has are hanging on the floor. So you don't do that. You go to somebody who's an art collector, and all of a sudden the situation is going to change. And so what happens is the so-called lower standard of care kind of systematically ratchets up through the selection bias. And the great advantage of this particular rule is you don't have the anomaly that's always been associated with fault theory of having somebody take on an obligation subject to a standard which he can't really comply with given his own limitations. You don't want to impose that upon friends, and so the system works this way. And as best I can tell, I can't think of any serious moral hazards associated with its operation. On the other hand, when you have the commercial bailment relationship, at this particular point, these are anonymous, high-volume transactions with people who are holding themselves out as warehousemen and so forth. And this kind of selection investigation is not going to work. So the way in which you economize on the information cost is you have a very low variance with respect to what it is that the guy who's receiving the goods is going to do it. He's doing it according to best practices. So at that particular point, standardizing the terms, the search now takes place mainly on price and convenience of location. And again, it turns out to be a relatively efficient sort of result. And so the theme of the paper, therefore, became how you do economics right without really trying. And the sort of object lesson that you have with respect to this, which the bailment cases I think are extremely useful at doing, is that the way in which I think law and economics ought to be done is to put the modelers out of business, at least as a first approximation. And I mean by that is, first of all, what you do is you look and you observe the way in which these patterns have emerged historically. And you come up with the basic intuition, Hayekian, I guess, of sorts, with those kinds of relationships which seem to be A, stable over time, and B, to be transportable across countries and boundaries with relative ease, are generally going to have relatively strong efficiency properties, because otherwise they would not meet the test for survival. So at that point, the way in which I think you do law and economics is that you run it backwards and say, aha, I see these arrangements. Instead of having learned Hand's formula, which in fact he misapplied in the very case to which he announced it, but that's a detail. What you do, you say, well, here's something that's going on. Now I'm an economist. What I want to do is see if I could reverse engineer the situation to point out some fundamental flaw. What you will typically find, however, is that there are anomalous cases in which the values, the cost, the benefits, and so forth are rather distinctive. And at that particular point, you don't want to change the basic rule, but you want to call attention to a feature which is very unimportant in Roman law, but may be important today, which is contracting out of default arrangements. What is striking about the Roman system is they believed in freedom of contract, and they were very strong believers in standardization of terms. And there's probably good reason for it, because of the difficulty of negotiating individual transactions with memory under those circumstances. But that's the way in which you try to correct for the anomaly, through variations in contract. And what I then do is I take the same kind of argument and do it to non-bailment cases, ending up in this point with the agency situations, and finally after the agency situations, talking about the frustration cases, where at this particular point what you do see is some kind of a fault criterion built into the rules. But interestingly enough, it never has any particular traction, because the kinds of situations that you're talking about, the effective control that is taken with respect to breach of promise, is that there's always an implicit bond by the promisor that he's going to perform, i.e. there are very few people, in order to escape painting a portrait under which is an attractive contract, will all of a sudden decide to turn around and to kill himself. So that the contracts tend to be excused without damages on death. And I think it was Douglas yesterday, or was it? No, it was you, Paul. Yeah. Who said yesterday, you actually look at most of these frustration cases, and it turns out generally they leave everything where they lie. The statutes which tried, like the Frustrated Contracts Act in England of 1943, to do it, essentially are almost never applied because they're highly idiosyncratic. And the basic intuition about this is as follows. Once you have these vis maior coming up in the situation, you think the incentive arguments don't matter very much. And so you're then worried about the distribution of windfall gains. And for that situation, every time you want to move them around, you have an administrative cost without an allocated benefit. And so that there's sort of the let things lie where they fall, which is what the windfall principle is. Where the wind makes the thing fall, that's where it goes. Instead of being the subject of taxation, as in the windfall profits tax, it turns out to be a convenient loan for the allocation of consumer surplus. So the old rules come out pretty well. The Hand formula does not. And I think that to the extent that we can move back with greater respect to traditional institutions, we will do better by ourselves. So I guess at 15 minutes I am finished. Can I take the first question from Omri is going to be about the difference in cost avoidance and possession, right?
No.
Oh, good. I anticipated that.
I could ask you about that. There are many elements of your anti-economist manifesto that I would.
It's not anti. It's just trying to teach you a new way of doing business.
Absolutely. You know, I think we're doing the business the way you are suggesting. I never thought that courts actually sit with the formulas. I thought the formulas help us understand what the courts do. But it's take one thing that I think is very fundamental in this argument, and that we've made it before, which I really don't understand. Maybe you can clarify. Why is the fact that we use objective standards, namely averages of some kind, instead of tailoring them accurately per incident, suggest to you that we're not using the hand formula? You know, you could take for example a damage measure, or some kind of loss measure. You don't know how to measure it precisely, so you use some kind of averages. You want to use the expectation measure, but you don't know how to measure loss, the loss profit exactly. So we use all sorts of averages. It still is the average of the expectation, which is different from average of some other thing that we're trying to measure. So when we don't want to invest too much in information exposed to verify what actually happened to this particular litigant, we can use schedules, averages, and stuff like that. But the point here is that the underlying thing that we're trying to measure, to average out,
is efficiency.
We're trying to measure out, and we've chosen to do it less or more accurately because of all sorts of costs. We think that we're not sacrificing too much in terms of deterrence, but are saving a lot in terms of verification when we use averages. So why is it now? The same applies to average standard of care. It is true that if we were able to identify the different propensities of different injurers to cause harm, we might be able to tailor for each a different standard of care. But we say, it's somewhere between 10 and 20. We don't know what it is. So 15, it might, and it's very likely to be consistent with what we see is the practice of care among professionals. We use 15. It still is a hand formula. It's just hand formula applied with less accuracy.
No, I don't think we disagree, but we do disagree on how we're doing it, which is this is a question of validity versus reliability. And I think everybody does understand, and this is a common ground between us, that an effort to try and tailor, particularly ex post, precise knowledge is based on the capabilities of individual persons is not doing, so we have to have some form of averaging. I think that the thing that we're doing is, if you go read the hand formula opinion, he does not, in fact, do that. He endorses a situation. He says the reason we could find no general formula of any sort is because we have three unique distinctive variables in each particular case. And so I hold, and that's all I hold in this particular case, is that the Connor company was under a duty to have a bargee on board, and they're liable because of his unexcused absence. I mean, so he's much more of an act utilitarian than you are. And in fact, your position is, I think, exactly the one that I was pushing for. I mean, I think there's a concurrence, which is to say, knowing the information difficulties, what we have to do is to find ways to sort of make averages. But what you're missing about this is that your stress is on the ex-post universe trying to make decisions, and my stress was on the ex-ante universe trying to pick out who's going to be your bailee. And the genius of trying to use the so-called ordinary care formula, taken more or less literally, is that what it does is it forces people to realize there's a kind of a best practice standard out there. They have to conform to it. So then when you're making the ex-post judgment, you're making it off a class of individuals for whom there's a much narrower variance. So you don't want to treat as an exogenous sort of random event whether you're talking 10 to 20. If you have a rule like this, the great thing about it is now all of a sudden you're looking at a variance between 14 and 16. So you get a much more precise situation. And in addition to that, you don't have to manufacture the substantive standard. What you can do is find out the standard of practice in this particular business was to put sprinklers in any kind of place where you're storing it. So having seen that, you then start to look at the deviation from that particular norm. And the ex-post venture takes on a very, very different form. As I said, this is not an effort to try and explain that the economic intuitions are unimportant in the Commonwealth. Quite the opposite. The point here is to explain that if you're a consistent economist, what happens is you realize that indirect techniques for solving cost-benefit problems and liability problems are always going to dominate the direct effort to measure the variables that the formulas will put to, and you'll always gravitate in that direction. So if you get this thing right in the ex post world, in the ex ante world, what happens is your ex post world is going to be much more easy to deal with. And so I think, in effect, that's why people tend to gravitate to ordinary care. To put it to you historically in the English context, but every case that you can find, sort of a general situation, where somebody talks about, the three variables in the hand formula. This is before 1972. I picked the date not quite at random. You can find 100 references to the man on the Clapham omnibus as being the appropriate standard, because what they did is they say, particularly in English trams, if you realize that there really were very, very powerful codes of behavior before the whole thing blew up somewhere in the 1980s, and that was the references. I mean, don't think of A.P. Herbert as a fool by virtue of the fact he used that metaphor. He picked Clapham because it was a good working class suburb in London, and because if you watch people getting on the bus, it was amazing how well they organized themselves. English queues were famous at the time. And what?
They queue up for the end of the world.
Yeah, I mean, you used to watch them when I went to Oxford. I mean, I'm thinking about this metaphor. The queue would be like this, and the bus would stop 10 places from the front of the queue, right? And what you did is you saw the people go around in a snake fashion, nobody trying to jump for the door. I mean, I said to myself, this is a civilized land that makes up for some of its socialist situations.
I'm surprised, given this, that you're looking at the Roman law tradition instead of the law merchant tradition.
Well, I do that too, if you want. Short paper, go ahead.
No, it's just that the argument I think you're making is just the, I think, rather familiar argument that we've heard from Dick and others over the years, is that you would expect in the contractual context that over time norms would emerge that would be efficient, because A and B could equally be likely on one side
that's right.
than the other. We have this long law merchant tradition that emerged that had ordinary standards passed without objection in the trade. Things like implied warranties, merchantability have been the law since the 13th and 14th century. I would think it's that tradition that you're trying to glom onto rather than these Romans.
No, but the law merchant comes out, of course, Roman tradition to some extent. I mean, it's not as though they're completely independent. You have a dominant system of law, which is Roman law, and what happens is that the customization that takes place inside the law merchant has the following proposition, which is certainly true, which is the greater the sort of the concentration inside the business, the more specific the norms could be, because there are very few people who cannot comply with them. The reason why I picked the bailment cases to some extent on the gratuitous side is because gratuitous transactions are not commercial transactions, and so therefore what you're trying to do is to solve a different problem, which is when you don't have convergence by way of behavior, how is it that you manage to have manageable standards ex ante, good selection effects, and then administrable standards ex post? And I think the subjective non-discrimination standard, which was the Roman standard, bring to the care of the goods of some other person. The standard that you brought to the care of your own goods is an extremely sophisticated standard, even though they had no idea that it was actually working through a non-discrimination principle. So I would basically say that there's no disagreement between us again. It's just a situation that I chose to talk about this part of the tradition. I did write a paper on the law merchant. I don't know if you knew this, a couple of years ago when Emily Cadiz ran our conference, which made exactly those kinds of points with respect to the situations. And the reason you like the transnational norms in these cases is that, bills of exchange and so forth were always going across countries, and so unless you had a uniform standard of law, you would always find yourself with the conflicts of law kinds of questions. And commercial guys can't tolerate these interesting exotic things, because the secret to understanding commercial transactions is what you have to do is have very high reliability and a very high velocity of transaction, which constantly drives you towards an extreme situation of standardization. And the bills of exchange were one version of that. The Roman guarantees, by the way, which again, and this is the Molitor, were exactly the same way. They gave you two standard forms, and you could pick one or you could pick the other. You had a word to describe each, and after that, everything else was fit, because you just could not afford customization when you're trying to figure out how to coordinate the activities between multiple guarantors of a single obligation. You just had to run it through that way. And I think that that's basically right. So I regard this as all as a piece, and I think it's kind of elegant the way in which it puts together and explains why the commercial tradition went as well as it did. More questions? Yes, Dick?
Yeah, I really liked the way you brought in the law of bailment, because it's an area that I don't know much about, and so it's interesting. But let me ask you a couple of questions about the ordinary care standard in bailment. These are ways in which it seemed to me like it might be inefficient, but maybe I'm just blinded by knowing theory.
We'll forgive.
One, you make the good point that if I'm the bailor, I have a fair amount of control in what's left as a bailor. Pick somebody who's careful and won't pick my stuff, his friends. Well, if that works well, that is, if I've got the information about my friends' habits and so on, then maybe the ordinary care standard is too high. Maybe that ought to be a rule of no liability. Basically, if the market's working well, we don't need any liability standard. So that's a question about whether ordinary care might sometimes be too high.
Well, no, actually, if it's a question of selection of a friend, the standard was bring to the care of your goods the care that he brings to his own. And this is to make sure that he doesn't get sloppy.
Yeah, although if I've got good information about it, quite possibly better information in the courts and applying an ordinary care standard, we might have a rule of no liability.
You might, but
the other possibility.
By the way, and you can easily get that through negotiations. Look, I'm willing to store these goods, but only at your own risk. And the moment that happens, however, is it can't be a no liability rule, because I didn't talk about these cases, but one of the other cases in the bailment tradition is the cases of unauthorized use. And sort of standard model of this is, I ask you to store my horse, I'm willing to pay for the feed, and then you run it in the Kentucky Derby and break its leg. Sorry, you're going to be held liable because it was essentially a consent for limited purposes. It was not an authorization to use it as you see fit. And you certainly wouldn't want to get those cases out from underneath the liability net.
My information was good enough about who's good about respecting unauthorized use.
Yeah, I mean, it's certainly good enough, but this is an argument.
Let me ask about the other
side.
side.
Okay, can I just say one second? That argument says it's good enough, you're going to reduce the frequency of cases where this will be litigated. It's not so good as to say that, by God, when the aberrant case occurs, it is always will, because the information is imperfect, that we ought to have no liability. Okay, anyway.
The other possibility where it might be too low, suppose I'm the Bailey, I've got some paintings in my house, not a lot, they're not worth all that much, I'm not a big art enthusiast, but I've got some and I take some care to make sure the roof doesn't leak and burglars don't get in and so on. Then my friend asks me to store his paintings in my house.
So you're the Modigliani's, right?
So now I've got twice as many paintings. Well, the naive economic theory would say I should now be taking more care than I do with my own, because now the roof leaks or the burglars get in, it destroys an even larger loss. So at first glance, it sounds like just saying I need to take the same care that I took of my own is too low, unless you sort of revise it to say the same care I would take of my own if I happen to have twice as many paintings.
Well, I don't even think so. I mean, I think it's a much more intuitive standard than this, which is that when you agree to have somebody take care, you're not asking him to make independent expenditures in order to improve the overall situation in the case. Because the moment you put that on there, Bailey's doing you a favor, and now it turns out he has an obligation to upgrade his house by putting in a bigger sprinkler system and a wall, $4,000. What happens is, if in fact the scale effects are large enough, two things are going to happen. He's not going to take them. He says, I just don't want this stuff in here. And then off you go to the commercial bailey where the scale effects will disappear because you can handle it through contract. Or there will be some special stipulation. What is interesting about these cases is that there are remarkably few bailment cases of which I'm aware in which special stipulations start to dominate. And the cases in which you do see it in the commercial side are all the familiar ones with respect to consequential damages, and so that you limit it to the loss or destruction of the goods. And then further, they use another variation on the general average contribution formula, which is to the extent that you wish to store something of unusual value, what they do is they have a general list which posts the maximum that's covered under their standard insurance contract, give you an option to buy extra so that the self-declaration is there. This is not an effort to extract monopoly profits. That's the crazy story that comes out of the Ayers and Girton stuff. This is, best I can tell, never an issue in any one of these cases. But what it is, a sense, is to handle the point I mentioned at the end of the discussion, which is when you have atypical transactions that don't fit conformably within the mold, it's at that particular point the variation is appropriate. And this is no different from an example, for example, to neighbor disputes, where you have an off-the-rack set of terms known as the law of nuisance, which is kind of complicated. It has both affirmative duties and negative stuff. It's a pretty good optimization approximation. And by God, it's not good enough, and if you need it, you then develop a system of covenants to pick up where it turns out that the base system doesn't work. Aria?
Well, my first question is maybe more a question of terminology, but I mean, on one hand, you could say that in bailment cases, in other contractual examples, you have different types of fault, right? One type, ordinary care here, and some other type of fault there. And I got the impression that that's actually what you say. And my question is whether, I don't know, maybe it's not important, but still, as a matter of terminology, a different way to define it is to say that fault is fault, But sometimes you need more or less than fault. Like the fact that sometimes the law requires gross negligence doesn't mean that the definition of negligence is changed. It just means that the standard should be different. And so I don't know whether it's important, but still I wonder what exactly you mean, the first or the second. And the related question is also the line that you try to draw between torts and contracts. It seems to depend also on that, right? So I think that what you say, but maybe I misunderstood it, that when we have this right, I mean, all those cases of bailments and other cases in which parties are not strangers, and there is a different type of standard or different type of fault, then it is contracts, while this is strangers, and then it's a kind of an objective one, and then it torts. And my question is whether that should necessarily draw the line between torts and contracts, right? You could say that even, take the bailment case. So suppose bailment, you need different types of fault. Still it will be torts, right? I mean, the fact that you need to have different standards, that's it by itself doesn't mean that we should call it contracts and not torts.
Let me just start with the very last observation. Yesterday I referred to the concurrence of actions in the civil law system, and in fact the cases of the destruction of goods under contract for hire could be sued either under the lex equilia or under the contract of ocutio conductio, which is their version of hiring. I give something unto you is what it literally kinds of means. And their answer was to drive it to convergence. But it took a little bit of trickiness because the original strict liability standard in stranger cases then got manipulated into a reasonable care standard by taking the word culpa, which meant sort of general responsibility, starting it to mean here's a strict liability case subject to expenses, which is what we heard about yesterday, and then turning into a situation saying, oh no, unless there was negligence as part of the prima facie case, there's no liability. And the convergence between these two sets of standards is pretty high if you take routine cases, which is why it tends to be a lawyer's dream rather than an ordinary person. But there is certainly that kind of difference. And the issue is, why would you want to torture the lex equilia if you can have a much more coherent view of this under the contract situation? The other reason why it becomes important in modern law is a different one, which is if you had a world in which you could contract out of torts by waivers and disclaimers, everything would kind of converge anyhow on a voluntaristic basis. But if you look at the tradition in American law, starting with the Baxter case in 1932 and roaring to the future with Henningsen in 1960, there has become a view which says that if you call something a tort, the contracting out procedure is either going to be difficult or impossible. Difficult under the UCC with respect to unconscionability and physical damages, and impossible under the restatements of torts, where in effect everybody knows that there's not sufficient information to contract out of liability with respect to physical injuries to a person, or there is to property damage. Mainly this is the Plaintiff and Defendant's Lawyers Preservation Act of 1998, because once you contract out, all the business goes away. The other point to some extent is terminological. The word fault is used to both to describe the genus and the particular species under it. In the most comprehensive fashion, it means anything which is blameworthy by any one of these standards. And then when you pick it out, it's the one standard which is either closest to ordinary care or the hand formula, depending on what it is, where there are others. Well, what you have to do is to figure out what the segmentation is going to be in the subcategories. And for that, the distribution of benefit test seems to have been the one that works the best. And one of the reasons, of course, why we do this is that there are two problems simultaneously that you have to solve. One of the problems is the level of care once he has the stuff, and the other is his willingness to accept the thing to begin with. And if you start putting objective standards on people who are kind of asked for favors, what happens is there's a built-in chance that they're always going to be in breach. They're going to always turn you down. And so the judgment is not as it's the optimal standard ex post. It's kind of like a patent problem. They're saying the alternative is to have slightly lower care than you might otherwise get in the Craswell berth, as opposed to having to leave the thing in your own basement when you go away for 6 months, where there's an even greater risk. And so the question here is never do you get to optimality. That's always hopeless. The question is, do you have an improvement? And if you have an improvement, you take the step, and then the issue is, can you make another improvement? And generally what happens is a kind of a law of, a magnitudes effect. You get the first and second order questions right, and almost nothing you do is going to get the third order questions right. And by the time you're down to that, What you really do is you go to kind of a reasonable care under the circumstances test, simply because the number of variations that take place at the third cut is so great that you can no longer do the system of design segmentation. And this is also true, for example, when you're talking about tort liability, say on the highway. This is the basic distribution. We have highway rules, and essentially we have two independent actors. The conclusive test for negligence in 99.9% of the cases is did you or did you not comply with the traffic norm. Every insurance adjuster understands that. And so you have me, you, both of us, and if it's neither of us, we just don't hit each other, so there's not a problem at all. What happens is, take something like last clear chance, you get the reaction function problem. I am sticking in the rules of the road, you violated them, I see it. Now you got to do what? Well, you can keep on driving exactly the way before, the guy's in your lane, you've got the right of way, you're going 50 miles an hour, you don't have to step on the brake, you ram him, he blocked your right of way. Everybody says, well, this is kind of crazy. Well, you have to brake. Well, how rapid? Do you brake or do you swerve? We're not sure. So what we say is take reasonable care under the circumstances, pointing out there's a problem, recognizing that once one car is off the rails, quite literally, there is no way that you can do what you can in designing the original system, which is to have the demarcations, the boundary lines, and the classification. What does this mean? It means in 1% of the cases you're going to get a mess. But in most cases, it's not going to be that problem. And if it's not that problem, what you do is you say, that's what we need litigation for. We need it for the residuals, but we don't need it for the cases that are amenable to the rules. Any other questions? Yes, Paul?
So, quick one, like the sort of Darwinian approach. The law that you have, what sort of burden of proof does someone bear if they want to change a common law rule by legislation?
By legislation?
What's the burden of proof?
I mean, you mean, legally the burden is that if those bozos can meet in time to pass the statute, it's just fine. I mean, there is no question that the hierarchical side of this business is we trump you. And my view is that with respect to the maintenance of public spaces and so forth, right, it's a pretty low burden. And what you do is you get communities together. And in general, if it's a question of whether we put a stop sign on Woodlawn Avenue so as to slow people down or not, I would say that the burden would be somebody comes up there and says that, kid got killed last week, there were 2 near accidents, we see what's going on, let's try to fix the thing. Very low. If it's a question of trying to intrude on private spaces, right? So when I now have a condominium association...
I mean a legal rule itself. For example, trademark law for hundreds of years rejects the delusions theory. Congress decides it's a good idea. Instead on the common law and pass a statute.
I would say...
What sort of, as an economist advocating for a change in the common law rule, what sort of burden?
Well, I mean, I would at this point, since you're doing legislation and you're not doing adjudication, right? I would essentially want to go to some sort of global efficiency standard and saying, here's the rule, I've looked at it, and this seems to be the kinds of non-cooperative, self-destructive behavior or socially destructive behavior that we've seen, and this is the sort of thing that we could do to counter it. So let me give you a real example, not out of trademark law, but out of the law of tangibles. The general rule with respect to the occupation of property, movables, is just picking the darn thing up, right? So the first possessor gets it to the exclusion of the world. And that's not a bad rule, but the moment you want to do deep sea exploration for manganese nodules, right? A real case. What happens is one guy goes there, he sees that these are concentrated in a location, he starts to put down there and he gets some of these things up. And what happens is you discover that the other guy is watching him, and the moment the first guy goes, the second guy goes in and free rides off of him. And so the argument would be the free rider effect essentially is destroying the value of the initial labor, and we have to switch to a system of property rights that stresses territories, and you move that way. And so, for example, when you see searches for gold and so forth, again, you stake claims, right, which give you areas to work in, as opposed to simply getting the rights of the gold that you take out of the ground. And that's a clear case in which you could show the inefficiencies. In something like the statute of frauds, where the common law rule is always oral contracts might be binding, let's say. Actually, there was no common law rule, there were other statute rules. You look around and you say the security of transactions with respect to a long period is such that we have to do 2 things. We've got to have them in writing, and in addition to having them in writing, what we have to do is have a system of recordation so that third parties can get notice of the operation. And recordation statutes were actually challenged on constitutional grounds, you know, as being an impairment on the obligation of contract back in 1832 or 3. And they rejected it essentially on the grounds that it created a systematic social improvement, although, just as you would expect, they couldn't use those words at the time because they didn't know what the hell it meant, but that was their basic intuition. the benefits to the realm would be sufficiently large that nobody could challenge the wisdom of such and such a statute. And we see lots of this. I don't know about it as well in the trademark area, because I haven't taught that specifically. But virtually every form of property that I've dealt with, with land and water and so forth, there are constant changes in property rights, and the ones essentially that work are where you can show real short-term effects, common pool effects, for example, of one kind or another typically, for which the stabilization of property rights by shifting from one system to another system of ownership will work. That's oil and gas unitization, it's the modification of water rights and so forth. So it's a big area. And the common lawyers, by the way, they were really good about this in the 19th century, because their attitude wasn't, we are an efficient set of rules. Their argument was that we did as best as we could with the tools that we had, but if there are problems that are beyond our scope, please, legislatures, come and fill it in. And that was certainly the attitude with respect to oil and gas, because it was very easy to see the destruction of the pools that took place through over-drilling. And then, of course, once it goes through legislation, all the special interests come in there, and they manage to pervert the statutes if you're not careful to guard against it. So you do have to worry about the public choice side, right, coming against the efficiency side. Yes, sir?
So it sounds like to me your argument, I guess there are two parts. One is that you don't like the idea of judges applying the hand standard, and you prefer the
on a retail basis.
Yeah, on a retail basis. You prefer the sort of rules, bright line rules, however you want to put them. But do you think these rules themselves plausibly are efficient? That is, they're what we would get if an optimal judge applied the hand standard over and over again. But I wasn't sure why you think that. Who are you pointing at?
Douglas.
Douglas, because
That doesn't cut with their.
I was just going to the avatar of bankruptcy and commercial law.
So yes, right. So there's the commercial. So I guess you think that to the extent that commercial norms arise and the judges are just imitating them, that's fine. But you make the argument about tort law as well, right?
No. Tort law, I think, in general, is much less room for variety now. And that's because the strict liability stranger rules tend to dominate, or if not that, negligence plus a strong dose of res ipsa loquitur. But do
you put as much weight on the tort rules, which are judge-made? They're not made in the marketplace. And then there's also, both in contract and tort, there are a lot of divergences. There's a lot of jurisdictions, common law jurisdictions, pick different rules.
I'm not.
And what are the judges supposed to do at that point? Are they supposed to, or what are we supposed to think about this? That if we think this is basically efficient, why would we have different rules and what should judges do?
Okay, well, remember, this is an embarrassment to all sides of the theory. So if you were to take a situation in which you believe that the hand formula were appropriate, you don't see its universal adoption everywhere else, you have to explain the variation across judges. I think there are two explanations, and the one that I like best is from Saul from many years ago, which is when you what? He knows exactly what I'm thinking about, right? He wrote these papers on the good faith purchaser, and there's basically a first order effect and a second order effect. No matter where you look, no matter what you see, you always see the bad faith intermediary getting hit with anything that you could possibly throw at. And so the real variation is between number 1 and number 3. That is the question of whether or not the original owner could claim the property from the good faith purchaser, which the standard common law rule, nemo dat quod non habet, you cannot convey what you do not own, would allow him to win against the third person, or whether you think there's sufficient inconveniences with that you allow the good faith to be a defense against him, forcing the other person to go back. This was actually a problem in the bailment cases. One of the major issues, and the basic Roman rule on this was the selection effect rule. Same one we talked about with Dick, which is, hey, you pick the bailee. If he's going to be faithless, you got to take the risk and chase after him. Don't ask this purchaser to do it. And one of the arguments which makes this extremely attractive is that the purchaser may be a one-off casual sale. Even finding the guy would be difficult, whereas you always know who your bailee is. Because in fact, when you show up and he doesn't turn the goods back, you could slap him with the summons. So I think what happens is that you get the optimal rule on the first cut, and what you're seeing in effect with the variation in the common law rules, to the extent that it does exist, is that on the second order question, where there's a genuine uncertainty as to which the optimal solution is, you don't know which way to go. And at this point, what you see in the individual jurisdictions is, again, an appeal to another second order argument, which is, I don't know whether the bailee or the third-party purchaser should take it, but the one thing I want is a rule one way or another so I could get rid of the uncertainty. And then you watch them and see the way in which they seem to work, and if one set of systems grouse and the other people seem to be reasonably content, you would expect to see a modest conversion over time. And in fact, you did sort of see that in favor of greater protection for third parties under these kinds of situations. But I see my time is up, and since I am a believer against temporal trespass, I shall forever hold my peace. All right, thank you all.